Oh, my brother was wonderful. He was full of life. He was extremely clever. He got the best GCSE results in his school just after he was knocked over.
Matty was 16 when a car crash left him in a permanent vegetative state.
The surgeon said to my dad that night, he said, "I've saved your son's life and we don't know yet whether that was the right thing to do."
With her mum and her dad, Kathy looked after Matty at home for 7 years. Eventually, they decided to let him die.
There's a line in one of the reports written by someone who, who's a specialist who does this all the time, and he said, "Matthew Minton is the most severely brain damaged person I've ever seen." And that was the level of his injury.
The family was subjected to months of inquiry, often intrusive, to get the final legal permission. Today, the Supreme Court would spare Kathy's family this last ordeal. A new ruling says that if families and doctors agree, food and water can be withdrawn without legal approval. There are thought to be some 24,000 people in a vegetative state in the UK. Some care can be withdrawn without legal permission, but to withdraw food and water, even if both the family of a patient and their doctor agree, it has become standard practice to apply to a court of protection to grant the order. This process can take months and be expensive. Now, the ruling means if a family and doctors both agree to stop support, they can do so without going to the courts. Some campaigners criticised the ruling.
They can effectively now be starved and dehydrated to death simply on the agreement by doctors and relatives that it's not in their best interest to go on living, and that can be done without any recourse to the court. We feel that is a retrograde step.
Removing the legal layer from the moment life support machines are switched off will concern some. But for this family, today's ruling would have made the agony swifter, even if no easier. Allegra Stratton, ITV News.